Maryland has a statute that makes it clear that vacation accrues and can be considered wages. For years, Maryland, from the administrative agency standpoint, took the view that if an employer had a policy that says you don't get paid for any vacation when you terminate, that was permissible. An employee challenged that in Maryland on the ground that accrued vacation was wages and therefore had to be paid on termination like any other wages, went up to the Maryland Court of Appeals. Maryland Court of Appeals not only agreed with the employee but awarded treble damages and attorney's fees, even though that ruling was directly contrary to the advice that the Maryland Department of Labor had been offering for a number of years. So Maryland Department of Labor, not surprisingly, has now changed their advice, but upon termination, any Maryland employee has to be paid for any accrued but unused vacation, or the employer is subject to treble damages on it. We don't have the same statute in Virginia, but the plaintiff's bar is very good at looking at what has been successful elsewhere and trying to make the same kinds of claims here. So be very careful about what your policy says on vacation. If it makes it clear to employees that they are earning vacation, that you will earn 1 day of vacation for each month of service, or that you accrue vacation at a rate of 0.8 hours every week of service or something like that, then there's a very reasonable argument that that is an accrued right, just like earned wages, and that an employee has a legal entitlement to be paid that when he or she departs. So be very careful. Look carefully at what your policy is. You don't have to have a policy that's written that way. You can certainly say during a calendar year you are eligible to take up to 3 weeks of vacation days with pay. That's permissible. There's no accrual to it. They're just entitled to that under your policy. So the way your policy is drafted determines whether or not you have exposure on that.